Are heirs responsible for a deceased parent's debt? Most heirs are not personally responsible for a deceased parent's debt. The debt is usually paid by the parent's estate, not by the children, unless an heir cosigned, was a joint account holder, is a liable spouse under state law, mishandled estate assets, or falls under another specific state law exception. I'm Rhett Fruitman, co-founder of Inherited Property Match. My background includes Citi Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not legal, tax, financial, or real estate advice. If probate, trust administration, creditor claims, or a sale of inherited property is involved, speak with a probate attorney, CPA, and qualified local real estate professional. What happens to debt after death? After death, debt becomes a claim against the estate. The executor, personal representative, or court-appointed administrator gathers assets, reviews creditor claims, pays valid debts in the order state law requires, and then distributes what is left to heirs. Do children inherit their parents' debt? Generally, no. Children usually inherit property only after estate debts, liens, taxes, and administration costs are handled. If the estate has no money left, heirs may receive nothing, but that still does not automatically make them personally liable for the unpaid debt. Do heirs have to pay credit cards, personal loans, or medical bills? Unsecured debts like credit cards in the parent's name only, personal loans that were not cosigned, utility bills, and many medical bills are paid from estate assets first. If the estate is insolvent, those debts may be paid only partly or may go unpaid according to state creditor priority rules. Do I have to pay my deceased parent's credit card debt? No, not if you did not cosign and were not a joint account holder. A joint account holder can be personally responsible because they legally shared the account. An authorized user is different. Being allowed to use a card does not automatically make you responsible for the deceased person's balance. When can an heir become personally responsible? An heir becomes personally responsible only when the heir had an independent legal duty to pay or created liability after death. The most common examples are co-signing a loan, being a joint account holder, being a surviving spouse responsible under state law, or serving as executor and mishandling estate assets. Executor liability is not the same as heir liability. If you are the executor or personal representative, the risk comes from paying heirs too early, ignoring valid creditor claims, using estate money improperly, or closing a sale without authority. That is why estate debts should be handled through the probate or trust process, not through informal promises to creditors. Can an adult child be pulled into a parent's debt? Usually not just because they are the child. Some states have rare filial responsibility or medical support rules, but those are state-specific and should be checked with an attorney before anyone assumes personal liability. What happens to a mortgage, HELOC, lien, or reverse mortgage after death? Mortgages, HELOCs, recorded liens, and reverse mortgages usually follow the property, not the heir personally. If you did not sign the loan, the lender usually cannot treat it as your personal debt, but the lender can still enforce its lien against the inherited home. What happens to a mortgage when the homeowner dies? The loan still has to be handled. If the family keeps the property, payments must stay current. If the family sells, the mortgage payoff is usually paid from the closing proceeds before heirs receive any remaining equity. A HELOC works the same basic way because it is secured by the property. Tax liens, judgment liens, and contractor liens can also affect title and must be found before closing. A reverse mortgage, especially a home equity conversion mortgage or HECM, usually becomes due and payable after the last borrower dies, although eligible non-borrowing spouses may have protections. Heirs should contact the servicer quickly because deadlines can be short. Can Medicaid or creditors reach inherited property? Creditors can reach estate property before heirs receive it, and secured creditors can enforce liens against the home, but that is different from making an heir personally responsible. The key distinction is personal liability versus estate liability versus property liability. Can Medicaid take a house after death? In some cases, a state Medicaid program may seek estate recovery for certain benefits paid during life, especially long-term care-related benefits. Medicaid estate recovery is not the same as an ordinary medical bill, and state rules, exemptions, and hardship waivers can change the answer. Can creditors take inherited property? They may be paid from estate assets, and lien holders may enforce their recorded rights against the property. But a creditor simply calling an heir does not prove the heir owes the debt personally. What should you do if a creditor calls? If a creditor calls after a parent dies, do not agree to pay personally. Ask for the claim in writing, request proof of the debt, avoid giving personal information to unverified callers, and direct the creditor to the executor, personal representative, trustee, or estate attorney. Should you pay first and sort it out later? No. Paying from your own money can create confusion and may be impossible to undo. If the collector says you co-signed, ask for the signed contract. If the collector says you were a joint account holder, confirm whether you were actually a joint owner or only an authorized user. What should heirs check before selling inherited property with debt? Before selling inherited property with debt, confirm the legal authority to sell, the title status, mortgage payoff, HELOC balance, recorded liens, tax liens, HOA balances, creditor claim status, reverse mortgage deadlines, and any possible Medicaid estate recovery issue. The practical sequence is simple. Find out who has authority, order title work, collect payoff statements, verify estate claims, resolve co-heir approval, and make sure the closing statement shows which debts are being paid from the sale proceeds. Once the estate, title, and payoff picture are clear, the sale can move forward much more smoothly. What is the bottom line for families? The bottom line is that heirs usually do not inherit a parent's debt personally. The estate pays valid debts first, secured debts follow the property, and heirs are personally on the hook only when they sign for the debt, share legal responsibility, mishandle the estate, or fall under a specific state law exception. If you inherited property and need help finding a broker who understands estate-related sales, Inherited Property Match can connect you with a vetted broker experienced with inherited property. The match is free.